to kind of start out, I don't know if you have like an intro slide in here, or if you want to just do maybe a little bit of a, if you don't mind, just a little bit of background on yourself, and then I can tell everybody why I was especially excited for us to have this session now.
Yeah, well, thanks everyone for attending. I'm happy to be here. My name is Rohit. I go by Ro. If we ever talk, you can call me Ro. Last name is 𝐬𝐵𝐻𝐿𝐵. I'm out in the San Francisco area. I'm a partner with a firm called Keller and Heckman, and practice in the Prop 65 area, but also have a pretty broad litigation practice. Also do some regulatory work. Keller and Heckman does primarily food and beverage law. Really, the bulk of our work is on the regulatory side, but we also have some litigators like me who handle the litigation and also do some of the regulatory work as well. And especially in Prop 65, we kind of do both sides. So I've been doing Prop 65 for probably close to 15 years. Other types of food litigation, a little bit less. But you know, Prop 65 is a very busy area in California. And I do all kinds of other litigation as well. So
all right,
yeah.
So I mean, just amazing. I mean, I think thank you so much for us to get the chance to really hear from a Prop 65 litigator is pretty awesome, and I hope everybody appreciates what a great opportunity this is. The reason that the impetus for this was I actually had a bunch of questions about Prop 65 that were, a pretty fine point of technicality. So I got in touch with Ro and we were talking through it. And I just was really blown away by how much knowledge he has, just like from obviously years and years of experience in this area. And so I asked him if he wouldn't mind just putting together a presentation for our community, because I know we all have these issues. And I think you'll hear from some people who just like don't want it to be a big deal, like, oh, don't worry about Prop 65. It doesn't even apply to you until you're like, 10 people. But also the reality is if you're selling into some of the natural channel retailers that a lot of us care about who are making better for you food, some of them might ask you like, hey, you must check this box if you can confirm that you're Prop 65 compliant. Like I personally, I mean, just, this being my first go around, did not want to have to be like, well, it doesn't apply to us because we're small, because it does apply to them as a retailer and they don't want to take risk. And so I think is just a much better strategy of like, just learn what you need to do when you're formulating your product. Probably if there's a flavor in there that's causing a problem, you can change the flavor now. Changing it later, like going back through the certification process, is a pain in the butt. I think if you can just get some of these tips the first time around, because all of us are going to be, thinking about California for sure, really valuable. And I think, hopefully also great for Ro, because I'm sure like almost everybody who comes to you, you have to give some form of this introduction to. So hopefully this will save you by having a couple dozen of these conversations at once. So thank you again. I know you've prepared some great intro materials for us, and I'll jump in with some questions along the way. And I expect we'll be getting a lot through the chat and FAQ.
Yeah, and I will follow up on the point you just made, because I think that's going to be the 10 employees or more. That's going to be a pretty important topic for this group, as I understand the size of the companies are a little bit on the smaller side. But you hit it right on the head with your comment there, but I'll jump into that as we go along. So anyways, I'll go ahead and start with these slides, but Daniel, feel free to jump in.
Oh, I will.
Sometimes when you're just staring at a screen for an hour, it gets a little bit weird, but I've done it enough times to be sort of used to it. So anyways, my first, I'll just jump through my first slide. This one won't be very exciting, but unfortunately we have to do it. I'll let you guys read it. Just a legal disclaimer, essentially saying that I'm just providing information here, and that I'm not actually providing legal advice to anyone today. Should be pretty clear. Got to put it in there anyway. So with that, I'll just jump in. So Prop 65, I imagine that there's some of you out there that have heard about this and are pretty familiar with it, like Daniel. Others may not be so familiar, and you know, that's okay. That means you haven't had the litigation filed against you. You haven't had a notice of violation that you've had to deal with, and hopefully it stays that way. Just in terms of background and what I'll kind of go through here today, I'll just go through a little bit of general background on Prop 65. Prop 65, as you can see here on the slide, is all about warnings. That's what we see in California on entrances to Disneyland, at restaurants, on products, in parking garages, just literally everywhere. And there's a lot of different examples of those warnings here. I will say that some of the warnings on this particular slide are outdated. So if you're trying to come up with a warning, don't necessarily look back at this and use it as a model. Some of these are a little bit outdated. I'll talk a little bit about the general safe harbor warnings and some changes on the regulatory side that are being proposed by the agency who kind of runs Prop 65. We'll talk about too, and I think this is pretty important, is you know, when is a Prop 65 warning not required if you have a listed chemical in your product? So I'll go a little bit over that, talk about some of the proposed regulatory changes in that realm for cooked and heat processed foods. And then lastly, and this is the area that's really, or second to last, this is the area that's really hot on the litigation side. Just so you guys get a background on what's going on, I'll go over a little bit the First Amendment challenges to some of the Prop 65 warnings and kind of the status of those cases. And then finally, we'll just talk a little bit about enforcement of Prop 65 and some of the, excuse me, some of the trends that we're seeing over the last year or two. So what is Prop 65? So this all started back in 1986 out of a ballot initiative. So if you're familiar with California, we have these ballot initiatives. Voters voted on Prop 65. The formal name is the Safe Drinking Water and Toxic Enforcement Act of 1986. It was passed by 63% of California voters. And I include this last statement here about the ballot summary because voters really were voting on being warned about chemicals that are scientifically known to cause cancer, not ones that are just merely suspected to cause cancer. And that this statement has been brought up in the current litigation around the First Amendment issues. So a little bit of information on the agency that administers Prop 65 and creates the regulations involving Prop 65 that we all have to work with, and that is OEHA, the Office of Environmental Health Hazard Assessment. It's a part of the California EPA, and OEHA administers Prop 65, but it doesn't have any enforcement authority. And we'll talk about who does in more detail, but it's generally private enforcers, and it can also be the California Attorney General, district attorneys, as well as some city attorneys if your city meets a certain threshold. But primarily we deal with private enforcers. So what OEHA is required to do on an annual basis is publish and update a list of chemicals that are known by the state to cause cancer, birth defects or reproductive harm. If you look at the statute, the regulations, and even the case law developed in California over Prop 65, they have confirmed over and over again that the listing of a chemical on the Prop 65 list can be based simply on studies in experimental animals. So even when there are no human studies, even if there is no clear connection to human disease, as long as there is an established connection between generally a very high dose of exposure and cancer, reproductive harm in animals, it's going to be listed. And the challenges, the litigation-based challenges to those listings have been unfortunately largely unsuccessful. The last one that we had was by the American Chemistry Council. They were trying to have glyphosate delisted, and that was unsuccessful just based on this body of law that requires listing. So we now have around 984 substances that are now listed. Fortunately, out of that 984, it's a much smaller subset that is actively involved in the enforcement and the litigation aspect. So most of these we don't see the notices of violations and the cases being filed, but there's a subset that are incredibly active. So what does Prop 65 require? Essentially, it requires what's called a clear and reasonable warning before exposing someone to one of the listed chemicals. So the rule essentially is no person in the course of doing business shall either knowingly discharge listed chemicals into sources of drinking water without giving a prior warning, or, and this will be the focus of what we're talking about today, knowingly and intentionally exposing any individual to a listed chemical from a consumer product in the workplace or a release to the environment without giving that clear and reasonable warning. And of this subset, I'll really focus in on the consumer product aspect of the warning requirement. So getting back to what Daniel introduced a little bit earlier, there is a threshold requirement that a business have 10 employees or more in order to be subject to Prop 65. Now, you might think, as Daniel said, that gives you a free pass. There are some questions, though, that can be litigated, such as if you're using what you're characterizing as an independent contractor, there could be some arguments from the other side as to whether that person is an independent contractor or an employee. Maybe that pushes you over into the 10 or more. I think even more importantly for a small company who's selling into California and who's working with the retailers like the Whole Foods, the Costco's, the Walgreens, most of those companies are going to require you to enter into a written supply agreement with them where you need to guarantee that your products comply with all laws and regulations, including Prop 65. They likely have indemnity provisions in there too. So to the extent the retailer gets brought into the case, the first thing they're going to do is to tender their defense to the manufacturer. And if that's you, even if you have less than 10 employees, you're still going to have to, if you're not named in the suit or in the notice of violation, you may have to defend a Whole Foods, defend one of the big retailers in the litigation. So that is a reason to be cognizant of Prop 65 and be kind of aware of some of the issues, even if you don't meet that 10 employee threshold. So the statute does define what a consumer product is, and it's pretty broad. It's any article or component part thereof, including food, that's produced, distributed, or sold for the personal use of a consumer. So there's a lot that's roped in there. We see Prop 65 cases for really anything and everything. Everything from VPA in movie tickets and receipt papers to lead in chains. We got a photo of a dog here, but in our office, we've got a case where a dog collar is the subject of one of these suits because it has a plasticizer in it that's alleged to create some exposure to people who are handling it. We've got cookies, biscuits, sunflower seeds, corn nuts, what have you. It's all out there. So this is a pretty broad definition. It really captures whatever you can think of that someone might be exposed to. Here's just a list of the substances that we deal with. Some of them more than others. But just to give you an idea of some of the chemicals that are coming up in food and also in food packaging. So lead, cadmium, mercury is very common. The acrylamide litigation has been going on for a few years and is really heated up in terms of the First Amendment arguments. Sulfur dioxide, even alcoholic beverages. We had a enforcement action by the California Attorney General that was focused in on the warnings that were being provided on websites for delivery companies doing alcoholic beverages, and also looked at their mobile apps. So there was a settlement a couple of years ago that addressed all that. In food packaging, BPA has always been pretty active and was the subject of an emergency rule a few years ago. DEHP also. So those are just some examples of the chemicals that we see in that are issued in the food related aspects of Prop 65. So what are these warnings? So
actually, let me just ask
yeah,
you
go ahead.
I think you probably are going to get into this, but those listed substances like lead and furfuryl alcohol, that kind of stuff, like I think probably everybody else understands this, but it's not like that would be the ingredient that is like for the product that you're selling, right? It's like stuff that can creep into what you're making. Like it could be that it is part of the composition of one of the ingredients that you're using, or it could have inadvertently gotten in there, right? Like I know.
Yeah, absolutely.
Right, with like lead, for example, like lead can get into like produce that's grown in the ground, and then it's still kind of on you to be testing to make sure there's not over a certain amount of that, right?
Yeah, absolutely. So that is related. There's a couple ways in food, especially. There's a couple ways that these chemicals get in there. One is, you got a crop, your raw material is growing somewhere where it just picks up a little bit of lead, cadmium, arsenic's another one as well. There's an exception for that. There's a warning exception for that, but it's really difficult, as I'll get into, it's really difficult to meet those standards to get that exception. There's also for food, some of these chemicals are formed when you heat a food, when you cook a food. It has to be done. And there's a proposed rule regulation that's out there. It hasn't been finalized yet, that 𝐕𝐢𝐴 is still considering, that deals with that issue and sets some levels for acrylamide. But that I'll get to that in just a minute. But that's a good point. Yeah, all of that stuff comes into play. So yeah, jumping back to this real quick. So what are the warnings? What is a clear and reasonable warning? So 𝐕𝐴, through its regulations, has come up with what they call safe harbor clear and reasonable warnings. So those are the warnings that are deemed to be sufficient and deemed to be clear and reasonable by the agency. In other words, if you use those and you do it right, use the right language, you're going to be okay. That's going to be deemed clear and reasonable. You're not going to get someone that says, hey, there's something wrong with that language. You didn't adequately communicate this, but if you use this language, you're going to be okay. So as of 2018, we have some updated regulations that came out of a very long notice and comment rulemaking process with 𝐕𝐴. But I'll just go over what the current warnings are. So the current warnings, you're going to need to disclose the identity of at least one listed chemical for each endpoint. And what the endpoint is, it's either cancer or reproductive harm. So you're going to have to include one of those endpoints. Also, for what's called a consumer product as opposed to a food warning, you're going to have to put this warning symbol that you can see here in the upper right hand corner. It's just that triangle, yellow triangle with the mark in it. You're going to have to use that. For food warnings, you need to use a box around the warning. There's also requirements for internet and catalog sales. The purpose behind those is to try to give the consumer a warning, before they end up purchasing the product on an Amazon or what have you, preventing the situation where they buy a product, it gets delivered to them, and the first time they're seeing the warning is when they open up the Amazon box. There's also a rule about foreign languages. If you're using, if you got consumer information that's in a foreign language, you're going to have to include that along with your English language. And let me jump to what these actually look like. So the safe harbor warning for your standard consumer product is going to use that warning language, the triangle, the language expose you to chemicals. You're going to have to include the name of the chemical, such as lead or acrylamide or what have you. And then it's going to say, which is known to the state of California to cause cancer, birth defects, or other reproductive harm. A lot of controversy around that, known to the state of California language now for certain chemicals, including glyphosate and acrylamide. Then you're including the URL for OES Prop 65 website. A lot of good information there. If you just want to get some more background on Prop 65, that's a good resource. The other good resource on the enforcement angle, and I don't have the URL here, but if you just do a Google search for California Attorney General Prop 65, you'll go to their enforcement site. It's a lot of good information there as well. And then the lower part of the slide here has got the warning for food. So it's a little bit different, uses the box. It says, refers to consumption. So those are the standard safe harbor warnings. There are some variations on this for specific circumstances. There's also another set of warnings that are called the on product or short form type of warning. You can see those here. This is an alternative to using the full length warning. It's quite a bit abbreviated, uses the triangle, the warning language, and then the endpoint. For example, the top one here is cancer. Again, has the URL. This needs to be actually on the product. So it needs to be on the product, on the container, the box, or the wrapper. There's some requirements for the type size. And so this came into effect in August 2018 under the rulemaking process that I just discussed a little bit. The agency intended at that time for these type of warnings to be put on very, very small products that had very little space on the for labeling. It turns out for various reasons that a lot of businesses really like these short form warnings. They're not as long. I think maybe there's some ambiguity associated with them. And so we started seeing these warnings on very large products. I mean, something like a appliance, like a refrigerator. Companies are starting to use these warnings on those. And that was not really the intent of the agency. So the agency has recently reacted to that and has proposed to do the following, is to limit the use of the short form warning, to essentially take that away, to have requirements that you can only use the short form warning if your product's got 5 square inches or less of label space. And when the standard warning won't fit, it's going to prohibit, if this rule goes through, use of the short form warning for those internet and catalog sales. The reasoning being there that you've got as much space as you need on your website or in a catalog to include the full warning. And if this rule goes through, it's going to require the name of the listed chemical and the toxicity endpoint to be included. Also, the words risk and exposure will need to be included. So it might be a little bit hard to read on the bottom of the slide, but this will be an example of what the full short form warning will look like once this goes into effect. There should be a bit of a grace period if this goes through for companies to change their packaging and artwork to include this full warning. But industry is arguing against this at this point. The last rulemaking process, again, was several years. Companies have invested in the short form warning that you can use now. And so the argument is we shouldn't be changing, 3 years down the road. So I think this is kind of an important slide, and it's going to touch on something that Daniel brought up. But when is the Prop 65 warning not required? And one of the really important things to remember is that once you get one of those Prop 65 notices, right? And now your company's in the crosshairs, you got to deal with most likely a private enforcer who's saying that you've exceeded the allowable levels of this chemical within your product. The important thing to remember, and the tough part of our Prop 65, is the burden is on you as the defendant to show that you come in, your levels of exposure for a particular product are going to come in below what's called a safe harbor level. So you can have within your product a level that will cause an exposure up to a certain point. And if you don't exceed that point, you're going to be under the safe harbor. You don't need to have a warning associated with your product. But the burden's going to be on the company in order to establish that. So what are the safe harbors? So for carcinogens, for a chemical that's been listed as a carcinogen, that's called the no significant risk level, the NSRL. So that is defined as the level that would result in no more than one excess case of cancer in an exposed population of 100,000 over a lifetime of 70 years. I say here that some are established, and that's because there are some safe harbor levels that are established under the statute, which will give you sort of a benchmark to assess your exposures from your product against. Not every chemical has those. And some of these safe harbors are pretty low. For acrylamide, for example, which is a chemical that comes up a lot in foods, that level is 0.2 micrograms per day. Very difficult to meet. There's a lot of argument that that level should be way, way higher than that. For the reproductive toxicants, it's called, the safe harbor is called the maximum allowable dose level. So what this is it's a no observed effect level, which is the point that basically the highest dose where you're not going to see effects, generally in lab animals. You take that and you divide it by 1,000, and then that's you're going to get you your MADL. That's going to be your safe harbor for your reproductive toxicants. Again, like the NSRLs, there are some that are established. There's a lot that aren't. So if you've got one, you have a benchmark to work against. If you don't, if it hasn't been established yet, it's a little bit trickier. If you want to fight your Prop 65 case that's been asserted against you, you've got to come up with that level. And that's something that generally is going to take the retention of experts. And there's no guarantee that the court's going to, go with that. And you're probably going to have a competing expert on the other side. So these are not easy things to do, but they are possible in terms of trying to support your company's defense. Now, getting to the naturally occurring in food exception, and this is what we were talking about a little bit earlier. So if there is a chemical that's naturally occurring in food, for example, you've got a certain plant that's got one of the ones that has been the subject of a little bit of litigation, but there's some plants that contain a chemical called, I think it's pronounced pulgone. And it's found in some herbal products, but it's naturally occurring. So if a chemical is naturally occurring within a food or within a plant that's used for a food, that would be naturally occurring. But even if it's naturally occurring, meaning it's not being pulled up by the plant from the soil, it's not a chemical that's being applied to a crop, but it's actually something that's created in the plant without any human activity. Even if that's the case, in order to have this exception apply, the company's going to have to show that you are using the best good manufacturing processes to reduce that level to the lowest feasible level. In the other situation where you do have, for example, a plant that's pulling up lead out of the ground, That's very tricky to establish because you've actually got to show that that lead that's existing in the plant didn't come from any human activity whatsoever. So you really need to show that that's coming really from a geological process, that that lead or arsenic or cadmium is in the soil and being consumed by the plant and is present in the plant just because of the geology of your local area, right? That is not something that is necessarily easy to do. In litigation, those challenges have generally failed. One that was successful was mercury in canned tuna. That was the subject of litigation and ended up at the appellate level, California state appellate level. But the defendant in that case had to show that the tuna was getting mercury in it essentially through this very kind of complex process of geothermal activity, putting mercury into the food chain in the ocean, and that essentially causing the mercury to build up in the tuna. So something that's pretty significant burden on a defendant to prove within litigation. But yeah, that's the naturally occurring exception. So knowing that it's kind of difficult to meet some of these safe harbors, given the naturally occurring exemption, OEA has proposed an amendment to its regulations that would deal specifically with exposures to listed chemicals in cooked or heat processed foods. So this is a proposed rule that's pending, hasn't been approved yet, but this would essentially establish that there's no exposure to a listed chemical if it's produced by cooking or heat processing, if quality control measures are utilized that reduce that chemical to the lowest level currently feasible. So there is going to be some burden still on defendants to show not only is the chemical in there because of heat processing and cooking, but also that you're using those manufacturing processes that lower it to the lowest level feasible. There is one sort of exception to that that's being proposed. This amendment would establish the maximum average and unit concentration levels for acrylamide in certain foods that would be deemed to be the lowest feasible level.
So, Ro, on this one, like let's say you're on this webinar, you're one of our attendees, and you're like, all right, I need to figure out if my product is Prop 65 compliant. And so the process at that point basically is to go to all of your ingredient suppliers, right, and ask them if all of the ingredients you're getting from them are Prop 65 compliant. And then theoretically, one of them could come back and say, actually, it's not, or we can't say that it is because it has this one chemical that is X, Y, or Z. Like there are a couple on there, I think, where this can happen. And that is a chemical that is produced by a cooking or heat processing, right? Which is means like if they, like maybe when they're making the flavor that you're using or something like that, there could be, yeah, other ways that could come in through the, like one of these cooking or heat processing kind of induced chemicals.
Yeah, like, I mean, if you are, a big one was roasting almonds, right? So you've got your raw almonds and you're gonna roast them. You're gonna heat them up, and that's gonna create acrylamide. There's really there's no way around it. That's a big issue for nuts and really essentially anything that's kind of a heavy carb-based food. If you're going to heat it up, if you're gonna fry it, if you're gonna bake it, it's going to create some level of acrylamide. So, yeah, you can check with your suppliers. That's a good thing to do, especially if they are providing you with the essentially the ready to eat, form of the product. If you're heating it or processing it, you might be creating some listable chemicals, furan, acrylamide, could be created during your processing as well. And so, one of the ways to start off is to, look at what are the concentrations of listed chemicals within your finished product. So you can do that by going to, there's plenty of labs out there to do it. Will cost a little bit of money, but, especially if you're concerned about a specific chemical, you can have them target that or have them look at kind of a broader array of some of the more common Prop 65 chemicals. But what that gives you is a concentration, right? So that's not equivalent to your NSRL or your MADL, which is a amount of exposure to someone in a day. That's different than the concentration in the food. So this amendment actually addresses that for acrylamide in certain foods. So I'll just flip to the next slide here. But for this proposed amendment, and only for acrylamide and only for certain foods, the agency is proposing that there be these maximum average concentration levels. That means essentially you're testing a few different units to get an average to see where you come out in terms of concentration, in this case, acrylamide. And then for some of these, there's a maximum unit concentration. So if any given unit is tested, you don't want to go over, for example, animal crackers. You don't want to go over 100. You don't want any unit to be over 100. But on average, you want to be below 75 parts per billion of acrylamide. So these are concentration levels. This is super helpful in terms of compliance because you can do that lab test and you can find out where you are in terms of concentration. There is some variability for sure. So the averaging does come into play. The roasted almond butter here, that was a proposal that was actually crossed off the list because some large manufacturers of those products went to OEA and they said, we can't even control the sourcing of our almond bits that are used to make the butter. They're just so all over the place that there's no real good concentration level that we're going to be able to adhere to. It may not be the 225 that the agency was proposing. So that got taken off the list. So, you might ask, well, where do these numbers come from? Is OHIA out there calculating these numbers, doing some science and figuring out that, okay, the 225 parts per billion or the 280 down here for the potato products, is that coming from some science that they're doing? And are they looking at their own safe harbor and establishing that they're coming underneath those? Absolutely not. These levels come from prior settlements between companies and essentially private enforcers where they have agreed to these levels as essentially a reformulation level. So we'll agree that we can adhere to this amount.
Bro, another question for you, which is, so like, does everybody then, is the answer like, hey, whoever you are, no matter what, you need to order a lab test on your product to understand the output, and maybe you understand all the ingredients and what's in them or not, but yeah, if you're the one roasting the almonds or you just have a product and who knows what's out there, like, does everyone just have to do a lab test? That's because like most of us we don't have your level of understanding of the products. We wouldn't instinctively know this, and we don't really have anyone on our team who would. Is that our only option, is just to start right away and get the lab test? Or are there ways you can know if that might even be applicable to you? And I was also going to suggest, and I'm curious to get a sense for kind of who's in the room today. If people wanted to put in the chat, like what kind of products you guys are making, just be kind of interesting to see a sampling of who's kind of tuning in today.
Yeah, someone's got here, I just popped up on the chat box, and there's a question about coffee. Can coffee be Prop 65 compliant? And how can you get around compliance for products that cannot be altered or roasted differently? So the answer to coffee is easy. A couple of years ago, OEHA, I think after a pretty significant public outcry and after about over 10 years in litigation against Starbucks and a lot of other roasted coffee manufacturers, actually issued a rule that exposure to listed chemicals from coffee is not an exposure under Prop 65. So it's not being regulated under Prop 65. That was an exception that the coffee folks got because the studies really didn't support there being any real harm from coffee. And in fact, some of the studies show that there's some health benefits from drinking coffee. So acrylamide is actually, coffee is actually a significant source of acrylamide in the diet. That was the subject of a lot of litigation over many, many years. The defense group that was fighting that actually lost. And then 𝐂𝐿 came in and created a rule to essentially exempt roasted coffee from Prop 65. So that is one way that it can happen, but there's no guarantee that's going to happen for every product. These levels here in the proposed rule are definitely helpful because it allows you just to go out and get that lab test. You know, it's hard to say, should you just go and run out and start testing your product? I think, you know, if you're selling into California, if you're gonna start working with some of the big retailers that are in California, they're gonna require compliance and they're gonna require you to indemnify. And I gotta tell you, this is a big issue that comes up for a lot of our clients is the requirements from the big retailers are getting more and more onerous in terms of what they want to see, guarantees of compliance. Some of them say we're not going to sell your product if it's got a warning on it. At the same time, you know, if you look at acrylamide and what the levels of exposure are, what the NSRL is, it's almost impossible to meet for any food based on your average consumer's consumption. If you look at the product labeling and the recommended serving size, you take that and multiply it by the concentration in your product, I can almost guarantee it's going to be over that 0.2 micrograms per day. It's just not a level that can be met. And like I mentioned, these that are in this chart are well over. These are going to put you well over the NSRL of that 0.2. But this is just what the agency is doing right now. And, you know, hopefully this does get adopted and, you know, hopefully over the years, additional chemicals and additional food will be added to this sort of list of levels that are going to be acceptable. But we'll see. We'll see if that happens.
Well, thank you. And I don't know if you could see, I don't know if you have your chat window open, but you can kind of see everyone jumping in, like listing out the kind of products they're making. Pretty cool to see the assortment. Like,
no, there's another question here about the almond butter. Are there currently no regulations with acrylamide for roasted almond butter? So I will say there's nothing specific like this, like would have been proposed in this chart, but it's still regulated. The levels of acrylamide are regulated. So technically, the roasted almond butter and actually everything on this chart, you know, again, this is just a proposed rule. This hasn't been adopted yet. So all of these products are subject to the 0.2 micrograms per day. Now, the only way, you know, one way to try to get around that is if there are consent judgments out there, meaning there are court-approved settlements that have been entered into for a product that is very, very close to yours, if not identical to yours in some respects, like if you're selling roasted almonds, there's many consent judgments out there at 225, especially if the enforcer that's coming after you has entered into a consent judgment at 225, you're going to have a pretty good argument that you can also comply at that level. So that hopefully answers that question. No, you're still, that almond butter is still regulated and is going to have to, for now, come within the 0.2 micrograms per day.
Okay. I also, there's another question that just came in the regular chat box. And it's a pretty interesting one. So Erica was saying, like, it seems like there are a lot of products that don't have it on their labels, but seems like they probably should. Like, why is that? And I definitely came across this and I asked our regulatory team and they're like, well, one, I mean, you don't know what's actually in their ingredients. So you don't know what exactly they're using, but two, they could be making a bet that no one else is going to know either. Or I don't know.
Right.
What do you think?
Right. Yeah, I think that's absolutely true. The enforcers haven't got to them yet, or the enforcers have got to them and they've agreed to a certain level in their product, which doesn't require warning. So when you get into a consent judgment, which is you've been sued, you've entered into negotiations with the enforcer, you've agreed to, okay, for this product, I'm going to agree at 300 parts per billion lead in, I think there's a question here about chocolate. So you're going to agree to some level of lead in your chocolate. Now if you adhere to that, there's no warning requirement. So a lot of the big chocolate manufacturers several years ago entered into consent judgments for their products where they've got levels set for various types of chocolate. For dark chocolate is in a special, used to be kind of a concern even with acrylamide. But certainly for lead and cadmium, there are levels that are out there, but not in the regulations. So you have to kind of look at the consent judgments that are out there, see what the enforcement levels have been. And then also there's another source too. You also look at, like I mentioned, the Attorney General's website has a resource where the Attorney General will actually, if they think a case has no merit, will issue a letter that they publish. It's publicly available on their website that talks about some of these products and that the Attorney General feels there's no merit, or there was a prior consent judgment that was entered, and perhaps the evidence that the enforcer is providing shows that they're below that level that was agreed to previously. So those are some situations where you can work with those levels that are established, and that's always super helpful, because otherwise you're really trying to find your concentration in your product. Then you're trying to find out, well, what does the average consumer consume of your product? There's various databases you can go to do that. A lot of times we'll go to an exponent or another expert to look at, what's the most recent consumption data for that product. Because you take your consumption level, you multiply it by your concentration, then you come up with, certain level of whatever, micrograms, what have you, and you can compare that to the safe harbor levels. So hopefully that answers the question.
Yeah, perfect.
Another one here is about the peripheral alcohol is also allowed in coffee now. So so the regulation that I was discussing earlier, that includes coffee as just as a final product, as essentially a formulation of a lot of different ingredients. It's got acrylamide in it. It's got, a bunch of other chemicals in it. So to the extent that your chemical is within a roasted coffee product, that's been exempted by 𝐸A under that regulation. So they weren't looking at, acrylamide or furan or the peripheral alcohol specifically. They just said, look, coffee has a lot of health benefits. There's no real science supporting any kind of risk of cancer associated with coffee. But so in that case, we're just going to exempt coffee as a kind of a mix of a lot of different things. So yeah, I think the question is the answer to that question is yes, you wouldn't have to warn about that.
All right, cool. Hey, I know we only have 10 minutes left, and I know you've got a few slides left. I don't know if you maybe want to just try to go to some of the priority ones, just because I know you have to run it.
Yeah, sure. No, I've got a bunch of slides left, but I will I've gone through a lot of the important ones, and let me go through just a couple more. Some of these aren't going to be as important for you guys. There's something called an interpretive guideline that also provides for certain levels that don't require a warning. If you're interested, go to the 𝐸A's website and look at the sulfur dioxide interpretive guideline. kind of interesting how 𝐿EA got there in showing that sulfur dioxide in soy sauce does not require a warning. There's also this First Amendment litigation that I sort of mentioned a little bit earlier, where a group of essentially trade organizations like the Cal Chamber of Commerce is challenging the acrylamide safe harbor warning, essentially saying that it's not, that the compelled disclosure of that warning is violative of their First Amendment rights, because California doesn't really know that consuming food with acrylamide causes cancer. So this has been a successful challenge so far in federal court here in California. There was a preliminary injunction that was issued. This is the warning that is at issue that is being challenged in the Cal Chamber case. Preliminary injunction was issued that prevented the filing of further acrylamide lawsuits. The enforcer then appealed up to the Ninth Circuit. The Ninth Circuit said, okay, hold off on this. Essentially stayed that preliminary injunction. So now acrylamide in food lawsuits can be filed, and they are being filed. This is just the standards for the First Amendment challenges. Purely factual and non-controversial is what Cal Chamber is arguing. If the acrylamide warning is required, it's actually not factual and it is controversial. These are sort of the court's findings on this. Really interesting reading if you want to check out some of the opinions out of the Eastern District of California. But what's most interesting here is the court focuses in on the fact that although there's animal studies on acrylamide, there's some in vitro studies that show a connection between acrylamide exposure and cancer. There's a bunch, I think at least a dozen epidemiology studies, which are human studies, that show have not established any increased risk of cancer in folks that are eating foods that can be high in acrylamide. So there are some issues with the warning, but what has the agency done in response to that? Because of the rulings that have been against it, the agency is kind of pivoting and has proposed this alternative warning. The comment period just ended a few days ago, but is shifting to now adjust the safe harbor warning to kind of include this longer description of what it's trying to characterize as the current state of the science, not using that known to the state of California language. So this is kind of unusual. This is going to be, I think, the subject of further litigation. We'll see what happens. This is all just kind of playing out right now. There are about 60 acrylamide cases that are in the Alameda County Superior Court right now. Those are moving forward, and the defense group is trying to use this ruling to make some arguments in those cases and get those cases stayed against one of the more prolific filers, EHA, and their attorney, the Glick Law Group. Now I guess it's an internal law group. Just a couple more here. There's a similar challenge on glyphosate. I really won't go into that because I think we need to jump into a couple other things on enforcement. But glyphosate, the challenge has been successful thus far as well. And again, the agency is now proposing this even longer warning about kind of the state of science of glyphosate in terms of its ability to cause cancer in humans. This is going to be the subject of more controversy as well, but that's what the agency is trying to do to address these First Amendment issues. Let's talk about, we've touched on some of this already, but in terms of enforcement, I talked real quickly about who can enforce. Most of the enforcement is done through private enforcers. Those are who either you as the company or your attorneys are generally going to deal with. Talked a little bit about the burden on the defendant to show there's no violation. There's two types of settlements. We've kind of gone over the consent judgment. That's usually a little more expensive than the out-of-court settlement. So the consent judgment is done essentially, it's approved by the court, it's reviewed by the attorney general, and it's entered into in the public interest. So what does that mean? That means that for those past alleged exposures that no other enforcer can come around and try to make the same claim. So it releases all of that potential past liability. Out of court settlement, you don't get that. It's more of a quick settlement with a single enforcer. Usually you don't see these lawsuits again, but it potentially happens. Excuse me, the penalties under Prop 65 can be pretty significant. $2,500 a day per violation per day. But in practice, this is not what the what's awarded or that is subject of the lawsuits. When the settlements are entered, usually the bulk of the settlement is attorney's fees and not penalties. So just a real quick overview here of the notice of violations that are being filed. Got acrylamide, lead, cadmium, BPA, DEHP are some of the hot ones right now. Sorry, I'm losing my voice. Maybe it's a good time for some.
I can ask a question. I'll think of, and by the way, if just because we're coming to the end here, if anybody else has any like urgent last question, you can probably follow up. And I know Ro is pretty good about answering questions, or if you want to reach out and get a consultation with him and Keller Heckman, highly recommend it. As everybody can see, obviously they know their stuff here. So yeah, I think probably that's like our worst fear for a lot of companies, is that like you're just going to get a lawsuit from somebody who's out there. I mean, really, they're like buying products, testing them to see if they can measure over any levels, right? Just pretty consistently. And I think, I mean, what I used to hear is like, oh, but you're not going to be on anybody's radar until you're pretty big. But then also have heard from other people like, no, actually, some of them might be targeting smaller companies they know can't really, you know, afford big legal fees. So I don't know. I think if you're worried about it, and I saw someone, just wanted to reiterate one point because I saw somebody else drop this into the question chat, like if you're selling direct probably on your website, probably it's not like, you know, if you're selling into California and you're not 10 people, and I mean, maybe if you have contractors and stuff, they could get you for being over 10 people, but it may not apply to you in that case. But if you're going to sell into retail, as most of us hope to, and you're going to sell in California, as most of us hope to, the retailers, a lot of them, I think, will ask you at some point, can you guarantee you're not in violation of any of the safe harbor or Prop 65? And I don't know, I think up to everybody to figure out whether they might be based off, or whether you might need to do a lab test or something like that. But hopefully this highlights for everybody what a lot of the risks are, where they could come from, or like, I mean, yeah, hopefully, but at the very least, I think probably everybody who's on this webinar knows about 100 times more than they did at the beginning of like, what is Prop 65? Where do these things come from? Do I need to worry about it? Right? Like, I'm a responsible person. I made this amazing thing to make the world better, but like, did something creep in there that I can get sued for? All right, back to you, Ro.
No, I hope it's been helpful. You know, yeah, feel free to reach out if you have any questions. I know, you know, it's only an hour, so we can't get to everything. But yeah, we're available.
What's a good way for people to reach out? Like, is LinkedIn a good way to do it? Or like, do you want, or you can give me your email. I don't know, whatever you prefer.
Yeah, sure. Like I think my last slide's got my email on it and phone number. So LinkedIn's cool too. I'm on LinkedIn. So got a question, you know, we're around, and this is what we do. So
yeah, no, thank you. And again, I did like, we just ended up doing this because I reached out to Ro because I had a question for the product that we're launching, and he like really explained it to us. Had a truly amazing conversation with him. So Ro, thank you so much for doing this for us. It's a huge service just for a lot of brands who were like infants in terms of how much we know about some areas of the law and like regulation like this. And so just Thank you so much.
It's don't feel bad about if you didn't know about this. There's big companies that get caught in this all the time. So as a startup, getting to know this, getting out ahead of it, I think is super valuable. So hopefully this can steer you in the right direction, or get you thinking about it so that you can maybe prevent from being a target.
Perfect. All right. Thank you guys so much for attending. If you know other companies that might have questions like this for Ro or Keller Heckman, I'm sure he won't mind if you pass along his email there. Thank you everybody for joining us and for all the great questions and engagement.
Thanks a lot.
All right. Bye everyone.
Bye.